Hello, I'm Bruce Stout, and I'm the director of the Subject Matter Experts Agency. This is a special report sponsored by Nath, Goldberg Meyer, an intellectual property law firm. This is a special report, how to increase your business valuation by building an intellectual property portfolio. Our first speaker and expert is Josh Goldberg. Josh, thank you for joining us.
Thank you for having me, Bruce.
So tell us a little bit about you.
Sure, I would be happy to. So I am an intellectual property attorney, specifically a patent attorney. What does that mean? It means I help people turn their ideas, innovations, inventions from something that's ephemeral in the air or existing in their head into a real world, concrete right, a certificate, a patent. What does that do? That helps them protect their markets to prevent competition. That helps my clients increase value in the company, perhaps by gaining licensing revenue, royalties from a company. And it helps increase the possibility of not only getting a funding event or a sales event, but getting the number you're looking for when you get into that sales event or funding event.
The all-important factor. So,
exactly.
Tell me, what's the likelihood that a company has overlooked products or processes that are candidates for a patent filing?
Well, if the company has never gone through an audit process before, or never really examined what they have, the odds are very strong, very high, that they have some valuable assets that they're not protecting. Most people think of inventions as something groundbreaking, earth-shattering, something brand new. And I'm here to tell you that's simply not the case. An improvement over something already existing can be just as valuable of an invention as something pioneering. Everybody thinks of Thomas Edison as America's greatest inventor ever. And everybody thinks of Thomas Edison as having invented the light bulb. Well, he actually was not the first to invent the light bulb. What he did is he did a lot of research to find the best filament that provided the most light, most efficient heating, most energy usage or best energy usage. And that's really what he did. He didn't invent the light bulb. He invented an improved light bulb that works.
That's really interesting because I've been to his laboratory in Menlo Park, New Jersey, and there is a prominent plaque that says Thomas Edison, the inventor of the light bulb. So I guess that was a little PR.
Exactly, that's exactly right. One thing that we do is we recommend patent searches to see what else has been done, what else is out there, to make sure you don't spend a lot of time and energy and effort trying to protect something that's already existing.
So Josh, let me ask you a question then. When we're talking about this, you mentioned an audit. Are you talking about an intellectual property audit?
Absolutely. So that's something where you go through, see what is the company working on? What do they sell? What do they hope to sell? What kind of research are they doing? What's happening in maybe packaging or manufacturing? Talk to everybody in the company to see really, what is the company doing that might be unique and different from others? And when we do this, we come up with a list, a punch list of all the different items we see that might be eligible for patent protection. Usually, the company can't go and protect all of them, and you have to make decisions where you're going to get your best bang for the buck. But until you have that list and know what the possibilities are, you really don't have much of anything.
You know, you were talking in an earlier meeting with us about shortcutting the patent process, and I found that really fascinating. Can you tell us a little bit about that?
Absolutely. So most people rightfully think that it takes a long time to get patents. The average is 2 to 4 years here in the US, from the time you file your patent application to the time you might actually get a patent. What we have determined and do a lot of is the Patent Office has a program where if you pay an extra fee to the government, because as we all know, the government likes to collect its fees, you go to the front of the line. That means that you get through the process within 1 year. Is that a guarantee of success? Of course not. But it is a guarantee that you'll know where you stand after 1 year. Do I have a patent or not? And there are a lot of business benefits to knowing that and being able to have that determination made.
I would imagine for a capital raise, that's an incredibly important issue for them.
100%, huge issue. If I can go to potential investors and say, hey, look at this patent or these patents I already have in hand versus, well, I have patent pending and hopefully we'll get there in 2 years. I know which one I'd be more likely to invest in.
Absolutely. So let's go back a little bit now. You were talking about some of the overlooked opportunities. And I imagine that some of those will be uncovered in this patent audit that you were referring to.
Absolutely.
Okay, so in that case, how are these overlooked opportunities impact the valuation of a business if the products or processes are later patent protected?
So if you get a patent for your products or processes, that says to a potential investor a number of things. Number one, you as a company, you as a business owner know what you're doing and you're looking to maximize your value to others. Number two, if I invest in you, the risk of not getting my money back is going to be lower because now there is some protection. There's something I have to defend that market of the company I'm investing in or the company I'm acquiring. I also now have assets as an investor that can be used for a variety of different purposes, licensing, receiving royalties, outright sale, that if you don't have those patents, those potential revenue sources don't exist. So there are a variety of ways or reasons that an investor would want to see that patent portfolio.
So a patent portfolio, when a company is being reviewed for a possible acquisition, the acquirer is looking at both balance sheet and sometimes off balance sheet items. So there is certainly value of patents, a patent portfolio that go beyond what's demonstrated on the balance sheet. Okay.
Absolutely.
So what would you say could be, say, the percentage of value of a company as it relates to a patent portfolio? I'm trying to pin you down on a number and you don't need to do that, but give me an idea. I mean, how relevant is that and how material could that be?
Well, the answer is going to depend a lot on the specific circumstances of the company. For example, if you're a biotech startup, for example, where you probably don't yet have any product on the market, and you're a long way from having a product on the market because you have to go through that regulatory pathway. Huge amount of the company valuation is going to be in the patent portfolio because without that, let's face it, you don't have anything. You would go through the regulatory pathway, you would get your approval at some point, and yes, you might have exclusivity for a certain period of time based on statute. But if you don't have a patent, you're not going to be able to extend that exclusivity and maximize profits once you get to market. On the other hand, if you're a big company, think like an IBM or an Apple, patents are absolutely a huge part of their value, but it's not as if the entire company value is based on patents because you now have sales, products on the market. Yet if you look at the IBM model, they generate a huge amount of revenue from royalties, licensing out or selling their patents. So you go somewhere from maybe all or most of your valuation being based on your patent portfolio to a percentage, half, a third, something like that.
That's significant.
Yep.
So let me pose a little scenario for you. You're a startup pharma company and you've developed a new drug and you're going to attempt to patent it. And Big Pharma finds out about it. Mm-hmm. And they have big bucks and they have huge practices of lawyers. How do you manage that situation when you're a small company and you don't have the money in the coffers to spend a lot of money on legal fees? How do you do that?
Well, Big Pharma these days doesn't do as much research on their own. Their R&D is looking to find those smaller startup pharma companies who have really great technologies, and they want to buy it from them. And then they develop it further to go through the FDA regulatory pathway and hopefully get to market. So the idea is, if you have a great technology, a new pharma compound, a new protein, whatever it is, you do your research, you show some good results, you protect it with patents, and you make yourself a good target for a pharma company to come in, acquire you or acquire the technology, pay you for it, and then let them spend the big money that's needed to get through the FDA.
Okay, that's really interesting. So what are some of the categories of companies that either would be subject to a patent attack more often? In other words, what industries? Or that because they've developed something are more likely to be acquired by a bigger company? What are some of the categories of those?
Well, I already mentioned the bio startups, the pharma startups is a company that would be, or a technology area that would be more likely to be acquired. On the other side, when you're talking about software technologies, that's where you see a lot of litigation right now. People who say, I have this software patent that covers X, Y, and Z. I'm going to sue Apple. I'm going to sue Microsoft. I'm going to sue everybody who might be using my software in some way, shape, or form. And that's where the so-called patent trolls really come in. That's where you hear about them and see them. They're trying to go after anybody and everybody who might be making money that might be implicating their patent.
Okay, that makes a lot of sense. So what a major challenge for companies is the theft of intellectual property. And so let's focus a little bit on patents. Where is patent theft most common, and what do you do about it?
Well, patents are, of course, in the public domain. So once you get a patent, it's out there for everybody to see. Okay, that's kind of the give and take for getting a patent. It's a legal monopoly. In return for that legal monopoly, it's for a short period of time, 20 years from when you file, and you have to tell others how to make and use whatever it is you invented. So where patent theft comes in, and this gets back to something you were talking about before, Bruce, if I'm a big company, I might say, hey, I see this patent is out there. I can do that too, and I'll challenge somebody else to sue me because they're a smaller company. I can ground them into the dirt with all the resources I have at my disposal. That's something that happens a lot of, but very often also, all it takes is for that smaller company to find another big partner, and suddenly you have two big companies fighting with each other, and it's not as easy for the big company number one to just bury big company number two.
So what happens if you're filing a U.S. patent and a company in Spain or Uruguay or Greenland decides, we really like this, we're going to use the same formula? How do you protect that? Is there a way to protect those?
Well, patents are territorial. So if I get a US patent that's only good in the US, if I get a Spanish patent that's only good in Spain, things like that. So if I have something patented here in the US and a Spanish company wants to do the same thing in Spain, and I haven't done anything in Spain, there's nothing I can do to stop them. They're free and clear to do what they want. I can stop them, though, from bringing whatever it is they're doing into the US to compete with me directly.
Would it make sense to file patent protection in Spain then?
It all depends on where your expected markets are, where you expect you might manufacture, where you might get materials from, where you're going to have activities. Nobody, and I mean nobody, is going to file in every country around the world. It's just too expensive. So you have to be really targeted and strategic. Here are the companies that are of most interest in countries, I should say, that are of most interest to me, that I'm going to get my biggest bang for the buck, and I'll file there. And if somebody does something in Uruguay, quite frankly, it's not a market I care about. I'm not expecting to get very many sales there. I'm not expecting to manufacture there. I can't cover everything, and that's a de minimis risk to me.
Well, what about if that company in Uruguay starts to export that to other countries that would have been your market? What then?
Well, then hopefully you have filed in those other countries, and then you can stop those exportations or importations into those countries. That's one of the things. A patent helps you do essentially 4 things: stop others from making, using, selling, and importing whatever it is that's patented. So if I have a patent and somebody tries to import what's the subject of that patent, I can stop it.
So we've covered a lot of ground here. What else would you like to tell us while we're still here?
The biggest thing that we did not talk about that I really want to make sure people know: prior disclosure, prior sale can absolutely kill your patent rights. So it's very important before you put anything out there to the public to talk to a patent attorney, to talk to an IP lawyer, and figure out, okay, is this something that can be patented? Should we file something now? Because if we don't and we publish, we start selling, that might destroy any possibility of getting a patent and protecting this product.
Why is that? Can you explain that in a little more detail?
Sure. So most countries around the world say, well, if you already put something out there in the public domain, you've already made it available to the public. Why are we now going to let you stop others from doing it? You've already given up your rights. You've made the conscious choice to make it available to others. Now we're going to give you a monopoly after the fact. Governments don't like monopolies. It's not something that they really want to be involved with. So they're going to look at it unfavorably and really only reward those companies who look after themselves, pay attention to what they're doing, and take the right steps.
So Josh, a company comes to Nath, Goldberg Meyer, and they want to file a patent, and you ask them, have you sold anything before? Well, 2 questions relating to that. One is, how often does that happen where there's been prior sales? And 2, if there is there anything that you can do to protect them?
It happens more often than you would think, not just with prior sales, but with prior publications. Prior sales, of course, from companies. Prior publications happen most often from professors, universities. Everybody knows publish or perish, right? So all the professors, all the researchers want to publish. In the US, there are still possibilities to protect yourself. You have what's called a 1-year grace period, where if you put something out there to the public, you have 1 year to file your patent application from that date, and you're still okay. Most of the rest of the world does not have that grace period. So, if you're a US only company, you might be okay. You might not care. If you're interested in sales markets around the world, you're really shooting yourself in the foot.
Final question. Company is an acquisition candidate. What should they tell a potential buyer about their patent portfolio?
Well, hopefully they have one, and they're able to tell the candidate or the potential acquirer something. They should tell them, look, here's our patent portfolio, have a nice chart or summary prepared for them, be able to explain to them, these are the products or services we have protected. Here are the things that are still under development that either we have applications pending or things still in the queue to get to applications pending. And maybe here's where there's still room to do more. So if you come in and acquire us, you have the availability or the possibility to get further protection in the direction that you want to take the technology.
Okay, this has been very interesting. How can people reach you?
Well, I'm always available by email at jgoldberg@nathlaw.com or by phone at 703-548-6284.
Josh, thank you very much.
Thank you, Bruce.
We're now going to continue our theme regarding intellectual property, and I'm going to introduce you now to Howard Kline. Howard, thank you for joining us.
Thanks for having me.
Tell us a little bit about you.
Absolutely. I am a trademark attorney at Nath, Goldberg Meyer. We specialize in obtaining valuable intellectual property rights, trademark and copyright rights in the United States, as well as internationally on the trademark side. And we really enforce those rights in administrative courts, cease and desist letters, as well as help companies continue to grow and build their brands.
Okay. Howard, what are the missed opportunities that companies experience as they relate to trademarks?
Absolutely. There are really three main missed opportunities. The first is relying on common law usage and not conducting trademark searches. So trademark rights are based on use. So a lot of companies and individuals just start using their trademark in commerce without really seeing, hey, is there another entity out there? And that's risky. If you're not conducting that trademark search, you have no idea if someone in Washington State has been using a similar mark for decades, or even if someone in New York filed an intent to use application a few weeks or months before you. So really having a trademark attorney do that initial search can save you and your company a lot of headaches and money down the line. Second thing is a lot of entities like to file for design trademark applications. And those designs are often valuable, but I often advise clients, hey, file the standard character word mark first. And the reason for that is the standard character word mark provides the broadest possible scope of protection. If you file that design trademark is limited to that specific illustration. And if you file in color, it's limited to that color. So if you change colors or designs in the future, you don't have trademark rights anymore. Whereas with the standard character mark, it provides the wording and any stylization, font size, etc. And finally, really companies fail to record trademark assignments with the US Trademark Office. And that's a real big issue because if you don't record that assignment and you then file a declaration of use or renewal down the line in the name of the wrong entity, your trademark rights are gone.
That's a lot of material to unpack.
Absolutely.
So a little bit more about this. So first of all, how often is it that a company loses their trademark rights because they haven't performed a search? Does that happen a lot?
It happens all the time. There are really two main ways you can conduct searches. One is on the US trademark database. So when you file a trademark application, the examining attorney is only looking to see, are there any trademarks that have been filed that are confusingly similar? That doesn't take into consideration real world usage. So if you just take a look at the trademark office and say, hey, look, it's available, and you file it, you may obtain a trademark registration, but there could be someone out there in Washington State or Texas that has superior common law rights that could potentially enforce those rights in court.
Does it make sense if you're going to file a trademark application to file it with several colors so that you have some flexibility later on?
What I advise clients, if they want flexibility, is to file in black and white. When you file that design mark in black and white, that provides protection regardless of what color you use in the future. Whereas you see entities that use blue and purple, if you then change it to orange and green, you don't have protection anymore.
That's great information. So Howard, what's the possible impact of these missed opportunities regarding a company's valuation?
Yeah, they can be huge. Trademark rights it's really who you are. It's your brand. And if you don't run that search, you get yourself going a year, 2 years down the line, then you have to completely rebrand. That's a headache. You need to get new URLs, potentially completely change who you are. So it can be really critical, as well as recording the chain of title. If you don't record the chain of title, and then you file a declaration of use, a party could then enforce those rights in court saying, hey, look, the wrong entity filed that declaration of use. And that can be critical in any type of merger, acquisition, et cetera, because if you don't have legitimate trademark rights, that'll reduce the value of your company.
Absolutely. Makes sense. Is there a way for companies to uncover missed trademark opportunities?
There are. One of the biggest piece of advice I advise clients is conduct trademark audits. And a trademark audit really is, you can have an attorney take a look at your website, take a look at how you're using your various trademarks online as well as in the real world, and then provide advice about filing in the US as well as internationally. Another thing you can do is take a look at what your competitors are doing, seeing what classes they're filing in, just to make sure. It's important to note that if you have a trademark for class 25 clothing, that doesn't mean you have protection for class 9 downloadable software. So just because you own trademark rights in one mark in one class, you want to be sure that you have yourself protected for all of the goods and services that you're actually providing in commerce.
So is there a trademark audit procedure that you can do to sort of uncover these opportunities?
There are. What we do as a firm is we take a comprehensive look at a client or prospective client's website, how they're using their mark, take a look at the trademark database and see missed opportunities and gaps in protection. And then we provide advice going forward. Another option is you can sign up for a trademark watch service. And that's really important. You can have third-party service providers take a look and see if your competitors are filing confusingly similar trademarks. You get a notification of that, so you can then enforce those rights.
Recently I heard a term that I was unfamiliar with. It was submarine filings. What exactly is that?
It's something that's growing in popularity. It's really the biggest corporations are doing it. And what we most recently saw is the Washington football team with the filing of the Washington Commanders. And what it is when you file a trademark application in the United States, you have the option to file with a use in commerce basis, an intent to use basis, or with a foreign filing basis. And what these companies are doing is they're filing first in jurisdictions that don't have publicly searchable trademark databases. So the Washington football team filed an application for the Washington Commanders, I believe in Trinidad and Tobago, and in early August. And what that really does is it provides a 6-month period of time for the Washington Commanders to file in the United States. And because they filed about 6 months later, they can claim that August 2nd priority filing date. And that's really critical because when you have these big corporations, they don't want leaks to come out. And you can get that 6-month priority date, scoop up domain names, social media sites, and then really, even if another entity files for Commanders on February 2nd, you have priority, even though you haven't yet filed in the US.
So if you do that, does that mean that, for example, the Commanders, do they also have to open up a stadio in Trinidad?
No, that's one of the big advantages. You don't have to rely upon that foreign application. So long as it's the first application that was filed, they can allow that to go abandoned, and they have that priority constructive first use date, but then they need to prove that they're using the Washington Commanders mark in commerce in the US.
Okay. Anything else you want to add?
I think that's it for now.
Howard, thank you very much. Appreciate all of your insights and your wisdom. Thanks.
Thank you for having me.